The Northwest Law and Mental Health Conference brings together expert speakers with legal, clinical, and lived experience to discuss the impact of the law on people with mental illness and addiction. Our spring 2020 conference was postponed due to COVID-19, so presenters recorded their sessions, which are now embedded in the conference website along with their collateral information. Thanks to all our expert presenters, generous sponsors, exhibitors, volunteers, and the planning committee for the Northwest Law and Mental Health Conference. Stay well, and we hope to see you in 2021.
Well, hello, my name is Thaddeus Betz. I'm a criminal defense attorney practicing out of Bend, Oregon. And I am going to attempt to give a web-based presentation today in place of our unfortunately canceled conference. I think I changed the title of the presentation from what was in the materials, but essentially what we're going to be talking about are the penological threads between juveniles and the mentally ill. This being a conference about mental health and the law, and myself having more of an expertise in the prosecution and sentencing of juveniles. However, we'll see throughout the history of both of those aspects of criminal justice that there are common threads between those two areas. So what I'm going to attempt to do is provide a brief history on the background of the prosecution of juveniles. We will see how that evolves over time, decades and centuries, where it intersects with the prosecution of the mentally ill, and then finally apply those principles and history to a case still pending in the courts, namely that of Kip Kinkel, who was a mentally ill child who committed a series of violent murders when he was 15 years old. So with that, some things we'd like to know about children. When can we try them as adults? When can we sentence them to die in prison? And look at that typo. What's the intersection with the criminal prosecution of mental illness? There's quite a history on the scholarship of juveniles dating back to our friend Blackstone, writing centuries ago, an Old English scholar. And of course, the English common law recognized that people younger than 7 were generally presumed to be not prosecutable. Those between ages 7 and 14 were presumed to be not prosecutable, but perhaps there could be some sort of court process where they were recognized to be what Blackstone referred to as capable of deceit. If they were found to be, I guess, mature would probably be the way that we would phrase it in modern times, then that child could be exposed to the full throat of the criminal justice system, including execution. And that was essentially the legal background of the prosecution of children for centuries, including into colonial times and pre-industrial revolution American legal history. For example, in the Massachusetts Bay Colony, they had enacted something called the Stubborn Child Law. Children were not routinely executed, and probably were very rarely, but the paper statutes did permit for the execution of children for what we would consider today to be minor crimes, or maybe not even crimes. So there was a strict code. It did involve quite hefty penalties for juveniles, obviously, for childish behavior, essentially. But again, I think history would reveal that these penalties were on paper, but were probably not frequently carried out. In 1899, our country sees its first juvenile court. It was established in Illinois, in Cook County had the first one. And it essentially provided the model for how juvenile courts operate today. They are non-criminal. They are intended to be rehabilitative in design and focused on reform and accountability. This was the first major reform for juvenile prosecution. And we saw for the better part of a century every other state adopt this non-criminal model, relax penalties that could be imposed on juveniles, and tried to develop a system where a child could be reformed but still moved to adult court if, as Blackstone would phrase it, they were capable of deceit or were mature enough to be exposed to an adult penalty. In the 80s, we begin to see some Eighth Amendment reforms to what kind of penalties a juvenile, or as we'll see a little bit later, somebody with a mental illness or a developmental disability can be exposed to. The Eighth Amendment, of course, bars cruel and unusual punishment. We will begin to see the court note how they determine what a cruel and unusual punishment is, and we'll see them time and time come back to a phrase that they refer to as evolving standards of decency. In any event, we have Eddings versus Oklahoma in 1982, reversing a death penalty for a teenage defendant, at least at the time that the crime was committed. In that particular case, the sentence of death on this child was reversed, not because the defendant was a child, but because the trial court had refused to consider what being a child meant, what kind of psychological damage the child had, what kind of influence the child had, what that minor status necessarily gave rise to. So the trial court refused to consider that. The United States Supreme Court said that's something we ought to consider before we impose the death penalty. A couple of years later, in 1986, we have Ford versus Wainwright. This is a case about mental illness. We begin to see that language of evolving standards of decency and the progress of a maturing society. What kind of penalties are we going to impose on that group of criminal convicts? And of course, we have to assume, to discuss Ford versus Wainwright, that this person was competent to be tried. They were not guilty except insane. But then at some point during the pendency of their execution, that this person became severely mentally ill. Ford himself was psychotic. That psychotic symptom, I think we can probably safely assume, expressed itself throughout his life, although really in the context of this case, we're just talking about an individual who was pending execution who began to display psychotic symptoms. The court there held that executing somebody who was so actively mentally ill that they didn't understand why they were being executed defeated defeated the penological purpose of that penalty. And so the court sends Mr. Ford essentially to be treated at a state hospital until he's fit enough to be executed. So we begin to see this strain beginning in Ford, where the Supreme Court recognizes execution of the mentally ill is a crazy thing to do, bars it as a penalty, but doesn't rule out the possibility that one can be restored. So, for example, somebody who is suffering from schizophrenia falls into psychotic symptomology while they're in prison, awaiting execution. They lose awareness of their circumstance or can't comprehend what their penalty is for. That person in that psychotic state can't be executed, but if we get them on their medications and their competency is restored, they recall why they are convicted and sentenced to death, then that execution is deemed constitutional. And in fact, that was reaffirmed in a case called Panetti versus Quarterman as recently as 2007. Again, the court there reaffirms Ford. If you can't comprehend the reason for your execution, it doesn't really serve any criminal justice purpose if you're killing somebody without them even understanding why. Panetti himself, the procedural and substantive history of his case is probably not uncommon for people who are severely mentally ill. Panetti had been institutionalized, I think, a dozen times prior to his trial. He refused to proceed with counsel. The trial judge recognized his mental illness and ordered a competency evaluation, found him to be competent, and ordered him to stand trial. Panetti was not taking medications at the time. He had been off them for some time prior to the murder that he did commit. He promptly proceeded to trial without the assistance of an attorney and was promptly sentenced to death. Later in collateral proceedings and appeals, I believe Panetti came about the Supreme Court in the context of a habeas corpus action. The Supreme Court again said he can be executed so long as he's competent at the time of his execution, but if his illness is expressing itself, then he has to be restored prior to that penalty being carried out. So we begin to see some movement on the court between what kind of penalties we can impose on children and what kind of penalties can be imposed against the mentally ill. In '88, not too long after Ford was decided in '86, we see a case, Thompson versus Oklahoma, where a 15-year-old is sentenced to death for killing his sisters and his own abuser. So that's, I don't believe it was a parental relation to this 15-year-old, more like a live-in step, like pseudo step-parent. But the court there recites, we have near unanimity amongst the states about what we permit juveniles to do and what we prohibit them from doing, right? We prohibit them from driving. We prohibit them from voting or marrying and purchasing cigarettes or alcohol or pornography or marrying, gambling, any variety of restrictions that we place on juveniles, implicitly recognizing that there is a distinction between juveniles and adults. even without knowing the science of it, it's something that strikes all of our lay experience. And so, of course, the Supreme Court says, look, these are things you at least have to consider prior to imposing a sentence of death against this 15-year-old. So the court in Thompson doesn't say that such a penalty can't be imposed against a juvenile. It simply says you have to think about those issues, about why a juvenile ought not to receive the same penalty as an adult. And that same year, in a case called Stanford, authored by former Justice Scalia, the court there went through some length to find that the per se death penalty execution of a child does not offend the Eighth Amendment. He does refer to the phrase evolving standards of decency. We'll see that get raised again in a later case on the exact same issue, but he sort of goes to point out that this isn't a terribly uncommon penalty. Some states have it. There's nothing so offensive about it that the Constitution ought to prohibit it. Well, sometime after, we have Atkins versus Virginia come out. That was not until 2002. Atkins essentially stands for the ruling that the developmentally disabled cannot be executed under the Eighth Amendment. Again, we see that same language where we're measuring what is cruel and unusual by the evolving standards of decency that mark the progress of a mature society. Atkins himself had an IQ of 59. He was convicted of a felony murder. It was unclear if he was the principal or the accomplice in sort of a robbery murder. Both Mr. Atkins and his co-defendant sort of blamed the other person for being the trigger man, but Atkins was convicted. He was sentenced to death. The court in Atkins said that if somebody is developmentally disabled, at the time in 2002, they still used a clinical term called mental retardation. So that's the language that it appears in 2002. I believe the DSM has altered the terminology for that disorder, but essentially Atkins is sent back down to the courts in the state of Virginia in order to determine if he is indeed developmentally disabled, and the state of Virginia continues to pursue his execution, sort of arguing about, is his IQ 59, is his IQ 70, what's the line between developmentally disabled and non-developmentally disabled? Hey, we'd really like to kill this guy. But eventually the trial judge finds evidence of misconduct in the case and just commutes the sentence to life in prison. So, but nonetheless, that's the law of the land and continues this day. We do have things that we refer to as Atkins hearings, where before somebody that is suspected of being developmentally disabled, can they face the death penalty? We would typically have a pretrial hearing that we refer to as Atkins hearings to determine if that individual could even receive that kind of penalty. A couple years after, in 2005, the court revisits its prior ruling permitting the Eighth Amendment to execute juveniles. Roper versus Simmons in 2005. Again, we're coming back to the standard of evolving decency. Justice Kennedy there says, hey, look, there's a wide body of scientific research that juveniles lack maturity, lack a sense of responsibility, Adolescents are found to be overrepresented in nearly every category. Reckless behavior. There's some brain development reasons for that. Plus, you know, the world's a different place than it was in 1988. And now the United States stands alone in the only country in the world that permitted the execution of juveniles. Probably not totally alone, but the vast majority of nations in the world had no death penalty for children at that time. So kind of crazy to think about. In 2005, I was still in law school, and there were still children on death row. But Roper versus Simmons does away with that, and the decision is based largely on this emerging body of science of adolescent brain development. Emerging science of adolescent brain development that we begin to see the United States Supreme Court pay a bit of attention to. We probably begin to see scholarly articles and scientific journals discussing adolescent brain development in the 1990s. There are several prominent psychological researchers. Probably the most notable name is Steinberg. You see his name again and again in Supreme Court opinions and all sorts of journals. But this is some language here on this slide from a case out of the state of Oregon, JCNV. That's the initials of the juvenile defendant. But we see it summarized. We've got an undeveloped prefrontal cortex of juveniles that make it harder for adolescents to have logical regulatory function. And teens now, notably, teens have more trouble than adults and even younger children in making choices. I think it's important to note that we're talking about brain development. So children, very, very young children, can regulate their behavior and their decision making just based on sort of parental guidance. But when the brain starts to develop at a certain age, normally I think the research is showing us that, you know, anywhere between 11 and 12 and 13 years old, we begin to have brain development. And that process occurs until about age 26. And that's when we begin to see difficulty in regulating behavior in particular circumstances. And what the scientific research shows is that there's a physiological reason for that. It was summarized. There's been a lot of testimony in a lot of different cases about science, because of course it is a reason why we ought not to impose the harshest of penalties on teenage criminal defendants. So there's a case that I worked on the second sentencing of, an individual by the name of Justin Link. He had been convicted in about 2000 with 5 other teenage co-defendants of murder of one of their mothers. In about 2016 or 17, the case was reversed by the Oregon Supreme Court and sent back for a new sentencing proceeding. And you'll see in this kind of excerpt of transcripts how this body of science, what this body of science tells us about juvenile brain development. And so this scientist is asked, you know, why are adolescents different? What's happening when you're a teenage adolescent? What is going on in literally in somebody's head? Dr. Bonnie Nagel is a researcher at OHSU. And she explains here there's a dynamic period, and essentially you've got two different developing systems in the brain. One of those is called the limbic systems. That's what she calls the emotional or appetitive reward system of the brain. And on the other hand, the other part of the brain that's developing at the same time, we've got a prefrontal cortex. Those serve to regulate behavior. Both of these systems are developing, the regulatory system and the limbic system, both of them in adolescence are undergoing radical and dynamic development. And it's sort of most pronounced in those teenage years, but you have a range, again, of a very young teen to somebody in their mid-20s. So we've got two different systems of the brain developing. We've got this emotional system of the brain that's going through extreme physiological changes. We've got the regulatory system going through extreme physiological changes. The regulatory system is sort of like the brakes on behavior. The limbic system is kind of like your most emotional and reaction-based system, impulses, right? So we've got impulses and we've got brakes. And the braking system needs to restrain your impulses. Now, is there one area that's developing faster than the area in this time of adolescence? And so, again, Dr. Nagel explains if you have a disequilibrium in these developing systems, the limbic system, and it is coming online in a quicker way, in a more radical way, in a more heightened way around the onset of puberty. And then the regulatory system, it develops slower and later. So all of a sudden, in these adolescent years, for purely physiological reasons, you have the reward-based system of the brain, the emotional side of the brain, developing in a faster and more powerful way, such that the brakes are taken off. And so now we have a disconnect between these two systems. The regulatory system is less mature and is unable to rein in the limbic system throughout adolescence. To any parent or anybody that's spent time around teenagers, this makes sense to us, especially because the research also shows that you can sit a teenager down, you can have a long conversation about how what they did was really bad and they shouldn't do that anymore, and then they could go right back out in that sort of hot situation and do the same thing again. Yet, on reflection, or in an environment that is not as emotionally charged, they understand that that was a wrong thing to do, or sort of bad behavior, but in the heat of the moment, that regulatory system is just not keeping up with the limbic system. There is a vast number of experiments that has validated this time and time again. They have these really nifty machines up at OHSU and many other laboratories around the country. They are fMRI machines, so they are brain imaging MRI machines where they can expose adolescents to all sorts of different scenarios, see what areas of the brain are firing, and sort of model you can be put in modeled circumstances and test which areas of the brain are working and which ones are not working. And we even see it in experiments where even when adolescents know it's an experiment and they nonetheless are given some kind of reward, for example, There's a study that's been repeated several times that I think most researchers just simply refer to as the driving study. A teenager is placed into a driving simulator, so it's not a real car. The test subject knows it's not a real car, and they drive around. And they drive fairly well when they're all by themselves. And then the experiment is altered, and a friend or another teenager is placed in the simulation with them. So sitting alongside you is your friend. And what do you begin to do? The person begins to drive recklessly, intentionally recklessly, and because it's funny, because their friend thinks it's funny, the limbic system is being rewarded. They're unable to alter their behavior in that hot and emotionally rewarding situation. That's just one example of a study that comes to the top of my head. But that research is well understood and not controversial. We see it incorporated in this whole line of cases with the Supreme Court, beginning with Roper, but continuing with Graham in 2010. Justice Kennedy there writing that a sentence of true life in prison, so one that would not permit any sort of release, any parole, any consideration of behavior, simply to die in prison, that penalty is unconstitutional for any non-homicide offense. So in Graham, it was a series of thefts, I believe. A child committed a series of thefts, was because of some of these kind of 3 strikes and you get life statutes that we see in Florida and California and lots of other jurisdictions. This person was a child at the time they committed these offenses, but tried and convicted as an adult, given a penalty of true life, and the court found, based on the 8th Amendment, citing heavily to this brain development research, that the penological justifications for sentencing a child to die in prison sort of collapse when you examine the juvenile brain research, because we know that teenagers make particularly poor choices, and that they stop making those particularly poor choices with age. So they have a profound capacity for reform, and they have a profound ability to do dumb things when they're teenagers. The court goes on from there in a case called Miller versus Alabama that came out in 2011. This was authored by Justice Kagan. There she wrote that mandatory life without parole. So we have a whole series of states that have penalties and statutory complex for people convicted of murder, where they just get mandatory life. So I think in Alabama, it was murder in the 2nd degree. Anybody convicted of murder in the 2nd degree gets life without the possibility of parole. There's no other sentence that a judge can deliver. Mr. Miller was 14 years old when he was convicted. He was tried as an adult. So the law made no distinction between children who were tried as adults and adults as adults. So Miller was actually a consolidated case of several different child defendants, and the court there ruled that mandatory life without parole violates the 8th Amendment when it's applied against a child, because a person delivering a sentence, a judge delivering a sentence, should be forced to consider chronological age and its features, not just the fact that somebody's a child, but what is going on when you are a child. What does that body of research tell us about the brain? What sort of influences was that child subjected to? What sort of abuse did that child receive? And she goes on to correctly point out that a sentence of true life for somebody who's 50 and commits a murder probably means 25 years, but a sentence delivered to a 14-year-old of true life is a number of decades longer. So it sort of flips on its head a normally mitigating factor, namely youth, and makes that penalty even greater against a child defendant than against an adult defendant. So Miller was a watershed case. It led to a lot of course, people appealing sentences, trying to find collateral relief for all those who were convicted as children in Oregon. I think at the time, there's probably somewhere between 12 and 20 prisoners serving a true life sentence that were juveniles at the time their crime was committed. But in other states, there's many more. California had hundreds. And we begin to, in the wake of Miller, we begin to see all sorts of states begin to do different things. Oregon doesn't do anything until just this last legislative session. Lots of other states begin to reform their statutes. Maybe surprising, we begin to see some states that normally have a reputation for some pretty extreme sentencing and sort of harsh criminal justice systems begin to reform. Texas reforms what can be done to a child. Louisiana does. Wyoming just sort of across the board grants the possibility of parole to any child defendant and any person sentenced to life as a child. Nevada. Several other southern states as well. Just this past term, the state of Virginia just simply granted the possibility of parole to any juvenile offender currently serving a life sentence. So we begin to see states start to peel back on what can be done to a juvenile. In Oregon, of course, we've had a couple different things going on with juveniles, some of which were amongst the harshest penalties in the country. In 1996, of course, Measure 11 was passed. It permitted the automatic and mandatory waiver of anybody aged 15, 16, or 17 into the adult system for 21 crimes. Some as innocuous, or some as least serious, as stealing classmate's cell phone with a buddy helping you out. That's what we call robbery in the second degree, with some sort of threat of force. All the way up to the most serious sex offenses and aggravated murder. So there's quite a range of crimes in there, but all of those category of offenders are going automatically into adult court, and they're automatically subjected to the exact same mandatory minimum penalties that an adult would face. Of course, with the exception that our statutes didn't contemplate that a child could be executed. But a juvenile prosecuted for aggravated murder who was 16 or 17 years old would presumptively face true life in prison. That changed just this last legislative term with a pretty serious reform that was entitled Senate Bill 1008. The politicking of Salem required ultimately that nobody currently serving a sentence can avail themselves of the benefit of Senate Bill 1008. But what it legislatively accomplished was the effective elimination of juveniles being prosecuted under the Measure 11 scheme. So what we've done is unwrapped Measure 11 for 15, 16, 17-year-olds, and we've simply gone back to the old system, which was if a child commits a serious crime or the state alleges that they do, then the court holds a hearing to determine whether or not that child's going to remain in juvenile court or whether or not that child's going to be remanded to adult court. And then Senate Bill 1008 also altered some of the penalties that a child can receive. A child can't receive true life in prison anymore. There is some possibility of parole for every person who is coming into the system new. And what was clear is that the bill barred any current prisoner from taking advantage of any kind of parole mechanism. And I think we'll come back to this at the end, but the pretty obvious, I don't even think it's a secret in Salem, is that the reason we can't do that is because an individual by the name of Kip Kinkel may be able to be paroled if we did that. And that's a political hot potato down there. So in Montgomery versus Louisiana in 2017, we have the Supreme Court again comment on juvenile sentencing. The issue with Mr. Montgomery, he had been in prison for 47 years. He was convicted as a juvenile, of course, in the state of Louisiana. He brought a habeas corpus action saying his sentence was now unlawful in light of Miller. And the question there before the court was whether or not the holding of Miller, that a juvenile can't receive a true life penalty, whether or not that can be applied to people currently serving a sentence, or is this something that can't be retroactive? And there's a whole analysis to that the court goes through, and they say, hey, this is a watershed new substantive law, so Mr. Montgomery can get the benefit of it. Footnote, he was denied parole recently. I believe he's still in prison. Miller has subsequently been released by the state of Alabama, but in any event, the court in Montgomery develops a new that Justice Scalia complains in a dissent is effectively does away with the ability to incarcerate a child for true life. Because what says is that in order to sentence a juvenile to true life, the judge imposing that sentence has to make a finding that the offender is permanently incorrigible. They use that kind of funny phrase, or another weird phrase of irretrievable depravity. But essentially what they're getting at is that rehabilitation is impossible. Justice Scalia in dissent complained, how could you say rehabilitation is impossible? We've got this whole body of research saying we don't even know if we don't even diagnose children with psychopathy disorder because their traits are so mutable, the transience of youth, this misbehavior that they're exhibiting disappear, but it's sort of impossible to predict. That's why somebody under the age of 18, the DSM doesn't permit those kind of persons. So unless we can prove to a judge, show to a judge in some way that this person has no capacity for reform, we can just say that now, then that sentence has to permit some chance of release. It doesn't say how many years it has to be in. The court doesn't get into what that release criteria has to look like. It's just has to have some hope for it. But The court goes on to say that, of course, appropriate occasions for sentencing juveniles to this harshest penalty will be uncommon in light of this standard that we just laid out. This holding in Montgomery was just argued again in October in a case called Malvo. Malvo, you may remember, I believe this was about 2000, maybe in the late 90s. There was, he was one of the DC snipers, you may remember. Malvo was a child. He had a co-defendant who was an adult, and they were kind of driving around the greater Washington, D.C. area, murdering people. Sometimes Malvo would even be sitting in the back of the car, and they would just shoot somebody driving down the freeway. They committed any number of murders. I couldn't even tell you how many in numerous jurisdictions. Malvo had a life sentence in the state of Virginia. Following Miller and Montgomery, he tries to find relief from his sentence so that he has some chance of parole. And in October, the United States Supreme Court took up the case, trying to figure out if this language of Montgomery was going to apply to him or not, whether or not the language of Montgomery would be retroactive and not just the rule of Miller. That's kind of getting down into the weeds of retroactivity and what we call the Teague analysis and habeas corpus issues. But as I mentioned earlier, the state of Virginia eliminated that penalty for juveniles, granted every juvenile the possibility of parole. Malvo's case then became moot, and the court recently dismissed it. So we don't know an answer to whether or not Montgomery, the language of Montgomery about permanent incorrigibility, whether or not that applies to everybody currently serving a sentence, or whether or not that's a forward-looking standard. That will have to wait for another day. This, of course, being a conference about mental health and the law, it begs the question of what any of this background on adolescence has to do with mental illness. And one particular case that sort of ties these threads together is Kipland Kinkel versus Pearson. Before it was titled that, it was called State of Oregon versus Kip Kinkel. But this case is still kicking around, and Kip Kinkel versus Pearson is a state post-conviction action where Mr. Kinkel, being the petitioner, is saying, hey, remember that Miller case? I'm not one of those juveniles that was found incapable of reform, where rehabilitation was impossible, where I'm permanently incorrigible, where I suffer from irretrievable depravity. You know, all that stuff was invented in 2011. I've been in prison for much longer than that, so I ought to get a second go at my sentencing because I don't think I'm that person. At his post-conviction trial, the judge in Marion County just says, well, you know, you've already complained about the Eighth Amendment back when you did your direct appeal in 2000, so you don't get to complain about it again. We're not even going to get to your claim. So he just goes away in summary judgment. The Court of Appeals agrees. Just by way of some background, when he was 15 years old in Lane County, namely Springfield, he was obviously a child. He was undoubtedly mentally ill. Doctors ultimately had difficulty labeling his diagnosis schizophrenic or schizoaffective with paranoid features or something in that realm of a psychotic illness that's related to schizophrenia. But he was, in the throes of his symptoms, unfortunately killed his parents. And then the next morning after doing that, walked into Springfield High School, killed several classmates, wounded many, many others, and also attempted to take his own life, both at the police station after he was arrested, and even inside the school itself. There was some evidence that part of his actions were intended to result in his suicide. But of course, at the time, this was 1998, I believe, and at that time, as we were discussing earlier, it was the era of Juvenile Measure 11. So he was prosecuted automatically into adult court and automatically faced those same penalties that an adult would face. At sentencing, well, without getting into the procedural details of his case, ultimately he pleads guilty to 4 counts of murder and I believe 26 counts of attempted murder. And there's a sentencing proceeding where the judge is to determine what length of sentence he's going to receive. Now, this is all pre-Miller, this is all pre-Montgomery. This proceeding is occurring in the fall of 1999. And so the law is unquestionably different. Eighth Amendment at the time didn't recognize that it was unlawful to execute a child. It didn't recognize that it was unconstitutional to sentence a child to die in prison without these particular findings being made. So really we're in the context of pre-Roper. Our statutes at the time didn't permit for Mr. Kinkel to be executed, but he could face every other penalty that the law allowed. So one individual that testified at his sentencing hearing was a guy by the name of William Sack, who was a professor and clinical practitioner at OHSU, Department of Psychiatry. And, he's of course asked to comment on whether or not Mr. Kinkel is capable of reform, right? So we already see this being talked about in 1999, just as a sentencing matter. It doesn't have the constitutional significance it has after Miller. But Dr. Sack comments that, if he takes medication, receives treatment, in 25 or 30 years, can he be better? The reason that phrase 25 or 30 years is brought up is because the lawyer asking him that question said, could he be better in about 25 or 30 years? The reason for that is because that was the least he could have faced. So the defense for Mr. Kinkel was asking for that penalty. And so it phrased to Dr. Sack, essentially after the minimum term goes by, does he need to be in prison anymore? Or might he be safely returned to the community? Dr. Sack says, takes his meds, gets under good care. I'd be happy to have him as my next door neighbor. Interestingly, Dr. Sack goes on many, many years later, I think in about 2010, to write an op-ed in the Oregonian, pronouncing that the continued incarceration of this child is just not moral, and he finds Mr. Kinkel to be perfectly reformed and just thinks this is all very silly. This continued incarceration, not the crime, of course. The crime is horrific. But Dr. Sack says he doesn't think that Mr. Kinkel would continue to be a danger to society if his symptoms are alleviated with medication. By way of background, Mr. Kinkel didn't know he had schizophrenia. Like many children that first develop a mental illness, they don't have the language or the tools to understand what command voices are, hallucinations. There's some tragic testimony in Mr. Kinkel's sentencing hearing that, he first begins to hear voices and just runs away from them. I mean, no child really understands what's going on. Dr. Orrin Bolstad also testifies. He is a psychologist, whereas Dr. Sack was a psychiatrist. Dr. Bolstad says, look, there's no cure for this kind of disorder, whether or not we're calling it schizoaffective or schizophrenia with paranoid features, but he does think it can be managed. You manage it mainly with medication, and he goes on to say how awestruck he is by how ill people can be given appropriate medication, and then how easily they can recover. And I think both Dr. Sack and Dr. Bolstad would tell us that medication doesn't work for everybody. It's not a cure to an illness, but the symptoms can be very well managed, and many schizophrenics recover and go on to live very functional lives. And so to conclude that they're not capable of reform and rehabilitation is of course just not medically accurate. Bolstad goes on to say that the people that have this kind of symptomology, this delusions, with paranoid features, with the benefit of medication, the voices can go away. In Kip's case, when the delusions and the voices go away, he expects that he would be, quote, pretty normal. So that's the context of Kip Kinkel. He committed a horrific crime against multiple people because of a psychotic illness that was undiagnosed at the time and not understood. And of course, now he's presenting himself to the court and saying, these symptoms are in control. I, like every other person with a psychotic illness, have this disease for the rest of my life, but I understand the illness, I understand the requirements of medication, and there's a large body of research now saying the worst symptoms of schizophrenics are often expressed early in the disease and they fade with time. So in any event, that's the context of that sentencing, of the evidence at his sentencing. Obviously, quite succinct summary. It went on for many days. And back in 1999, the court says, in a nutshell, rehabilitation's not the important part, right? It's apparent that this sentence needs to account for each wounded person, okay? There's a price to be paid for each bullet. And the court called the doctors who testified impressive, and they, of course, appropriately focused on him as his condition rather than what an appropriate sentence would be. And, here's a court making a finding. They generally agree with extensive long-term treatment. They would not expect him to be dangerous. So even the sentencing court back in 1999 recognizes, with appropriate treatment, Mr. Kinkel can be safely released. They don't expect these symptoms to continue. This testimony is not contested by the prosecution. The court doesn't cast any doubt on it. The judge acknowledges it and ultimately rules that that's not the most important thing in the case. The most important thing in the case and the sentence is that a price be paid. So a sentence based on retribution really is what the theory of justice is there. And he's given a 112-year sentence with no possibility of release because it's a stacked measure 11 sentence. So to sort of jump back to Mr. Kinkel's post-conviction case after Miller, right? Hey, Miller was decided, Montgomery was decided, the judge had to say that I wasn't capable of reform in order to sentence me to die in prison, but that never happened. So shouldn't I get a new sentencing hearing? Like, we need to talk about that. Those terms didn't even exist in '99. There was no, there was of course no finding of irretrievable depravity, because no jurist had ever heard the phrase before. And the same with permanent incorrigibility. It wasn't something that we were even supposed to be paying attention to. Interestingly, Mr. Kinkel's lawyers at his sentencing and his direct appeal in 2000 essentially made the argument that Miller versus Alabama later adopts. Of course, at the time, that wasn't the Eighth Amendment law, so the Court of Appeals just said, go away. But anyway, interestingly, just by way of reminder, in Mr. Kinkel's post-conviction action, where he's saying my sentence violates the Eighth Amendment because of Miller, because these findings weren't made, I should get a new sentencing proceeding. Both his trial, PCR, and the Court of Appeals, they both say, we're not going to address the merits of your claim because for these procedural reasons you already talked about it once in your direct appeal, we're not going to talk about it again. So he just kind of gets what we call procedurally defaulted and just shoved away. We don't care about the merits, the substance of your Eighth Amendment claim. We're not even going to talk about it. The Oregon Supreme Court went to the merits. They said, okay, let's talk about the Eighth Amendment. We'll just assume that you survived these procedural difficulties. Which is kind of odd because, of course, normally, if we're going to talk about the merits of something, both the state of Oregon and the petitioner would have an opportunity at the trial level to sort of fully develop the facts and the record for the high court to review. But Justice Kistler just gets right into it. And what he ultimately writes for the court, with one dissenting opinion from Judge Egan, is that we're going to take the child out of the child. So we're going to make Mr. Kinkel a non-child. And what is Mr. Kinkel? Mr. Kinkel suffers from an incurable mental illness. Because petitioner's psychological problems diminish his culpability for reasons that are unrelated to his youth, so they're independent of and separate from concerns of Roper, Miller, and Graham. So his psychological problems, while they're relevant mitigating evidence, sentencing court thought about it, but that's not the same thing that led to reversals in Roper, Miller, and Graham. So never mind that he's actually a child and that the findings weren't actually made. The court said, because your crime emerged because of a mental illness, you're categorically okay to die in prison. That's ultimately the holding of the Oregon Supreme Court's decision in Kinkel in 2018. Of course, not terribly long after Mr. Kinkel's case comes out of the Oregon Supreme Court, that very same body reverses a sentence of true life for different defendants that were also children, also sentenced to die in prison, and attempted to draw a distinction between Mr. Kinkel's case and their case. So to kind of tie this in together to our the theme of this particular conference, what's sort of the fallout of this kind of decision? I think it's quite alarming. Because in effect, there's an uncontroversial body of law that a child can't be sentenced to die, except in these extremely rare circumstances, sentenced to die in prison. But now we have this sort of carve out for the mentally ill. And so a youthful mentally ill individual can be incarcerated forever. but the otherwise healthy person can be released. The youthful healthy person can get out. The youthful mentally ill person can simply be left to rot. And what does that mean for our juvenile justice system? Well, 50 to 75% of offenders in the juvenile justice system suffer from a mental health disorder. So now we've cast open this door where a judge just simply has to go down the road of labeling somebody mentally ill instead of a transient youth, and can expose them to the harshest penalties that we have. Interestingly, psychotic symptoms are some of the most common that you see in the juvenile justice system. And a very small fraction of those children who experience severe mental health symptoms as children have a lifetime of that. So the general proposition that a seriously mentally ill child can now be sentenced to die in prison, it seems to run counter to how we think of mental illness as being a mitigating factor in court, but also inconsistent with the science of mental health. We've got this normal, well-recognized reason to treat somebody more leniently, namely, hey, this child committed a crime, or this person committed a crime. They have a mental illness. It's manageable with medication. So, judge, let's be nicer to this person than we would be to somebody that didn't suffer from this illness, right? Regular mitigating factor. Couple of example cases on that slide of just saying, yeah, well, you got a mental illness, we'll give you a reduced sentence. That's just kind of bread and butter criminal sentencing stuff. But Justice Kistler in Kinkel just flips that entire concept on its head and says, a 15-year-old who has no mental illness, commits multiple homicides, is eligible for release. And somebody who, no fault of their own, suffers from a mental illness, commits a crime as a result of that illness, which the court recognized, can be incarcerated for life despite uncontroverted testimony that the disease is controllable, can be ameliorated, can be treated, etc. That ties together, I think, the threads between what we see with juveniles and mental illness, and now we're at a sort of a crossroads, at least in this jurisdiction, of how we're going to reconcile. And just by way of update, Mr. Kinkel continues to pursue relief from the sentence. We believe it's unconstitutional. I currently represent him in federal district court here in Oregon, where we have a habeas corpus proceeding, essentially challenging the conclusion of the Oregon Supreme Court that Miller doesn't apply to Mr. Kinkel. That marks the conclusion of my presentation. I hope it was informative and helpful.